Hey, ladies and gentlemen, this is Carmine Sabia for Explain America, and you know they went too far when even an MSNBC host has to give them a smackdown. Before we get started, please make sure you like, comment, share, and subscribe. Those little things really help us out, and they help our channel continue to grow. Now, MSNBC host Katie Tur was live after the Trump verdict of a massive, close to $400 million decision against Trump and his sons. That being said, she looked at it and she said, you know, is this fair? She talked about the fact that she's never seen anything like this in New York. She's looked at other cases, and when there's no victim coming forward saying I was victimized, you know, this kind of thing is rarely brought, and the punishment never has been this severe. So is Trump getting the, hey, you're Trump and this is a liberal state treatment in New York? I'll let you guys decide that. I know what I think. I think that's absolutely what happened. I think there's a lot of people like Judge Engoron and Letitia James that are trying to use this case to springboard their careers. I think in his own case, Alvin Bragg is using Trump to try to springboard his career. So none of this is a surprise to me. You got to understand, Katie was on there with people who absolutely make no secret about that they loathe former President Trump. So they were definitely taken aback by this. And, well, her audience was taken aback by it. She was trending for all the wrong reasons on, X, formerly known as Twitter, yesterday after she said this. So I want you to watch this video and let me know if you were surprised by it. Also, please make sure you like, comment, share, and subscribe. It really helps us out. I'm Carmine Sabia for Explain America. We love you guys. God bless you. Take care, everybody.
Statements might not be so lucky.
I'm looking for a little bit of reporting that the Associated Press did regarding these sorts of decisions, these sorts of investigations, these trials. I'm just not finding it in this pile of papers that I have in front of me. But basically, they said they went back over 70 years and looked at all the cases that have been tried under this rule 6312, which is used here, which doesn't have to show harm done. That's not the burden. You don't have to show that anybody was hurt by your practices. There's nobody you defrauded specifically. But they went back and they looked at cases over 70 years. I believe it's about 150 cases, and found that there was no case where there was a ban on doing business where there wasn't harm shown. So even though the threshold is harm shown, in the past, it has only been used to ban someone doing business when it's been shown that somebody was hurt. Say you're selling cosmetics that are poisoning you. There's somebody that was hurt there. The cosmetics company gets banned. Is this fair to go after Donald Trump like this in this environment? Is my question.
Well, look, I think what you said about the statute is absolutely true. Tristan Snell, who just joined us at the table and has used the statute. I was going to introduce him, but we can introduce him now as well. Tristan Snell is here. He's used the statute. Well, let's ask Tristan. So you use this, yes. 6312, in the Trump University suit, yes. A university that was scamming people, wasn't actually giving them useful information for them to do business.
And wasn't licensed and wasn't a university, et cetera, yes.
Yeah. So tell me, is it fair?
Look, the thing is that the notion that 6312 is this sort of weird thing that shouldn't be applied and so forth and so on, this statute and the statute that was based on, which is called the Martin Act, which may be the one that people are more familiar with, the Martin Act applies to securities. The Martin Act was put on the books in New York about 100 years ago. We have a lot of case law to support this. This statute is used by the AG's office every day against all sorts of other frauds and misdeeds. The legal standard is whether there was a tendency to deceive. That's what it is. And the legislature in New York made a public policy choice to say that that was an important weapon for the AG's office to have to vindicate the public good in this situation.
And it seems like what Judge Engoron found was there was intention, not just a tendency, there was intention to deceive.
Which is even higher than they needed. It's basically, if the bar is here, the evidence went way over the bar.
I mean, he's saying when confronted at trial with statements, defendants, fact, and expert witnesses simply denied reality, and defendants failed to accept responsibility or to impose internal controls to prevent future recurrences.
Under 6312, you don't need intent, but intent becomes an aggravating factor. So that's part of why we see the penalties so high here.
I know this feels like a lot. It's a 93-page decision. We're all trying to go through it. And